And now it's time for Mike's Spotlight on Industry Leaders.
Hey guys, welcome back to another exciting episode with JL Carpenter on Industry Leader Spotlight. She specializes in criminal defense as an attorney, and she is one of the top defending attorneys here in the state of Texas. So we've got some very interesting stories for you today. And the goal of these stories is to help you understand and learn that just because you're accused doesn't mean that you're going to jail if you have proper representation. But you have to remember that this person specializes in this field, is a great trial attorney, and is what impacts your representation is 100% tied to the aftermath of this process that you're going to be involved with. So we've got 3 stories for you today to share that are just absolutely amazing, especially the results for her clients. First of all, we're going to start off with a felony assault, domestic violence. The next one is going to be aggravated assault with a deadly weapon. Need to pay attention to that one. And the last one is felony DWI, which is so common today. It's amazing. But what you're going to find out is there's no alcohol involved in this conversation. So pay attention. This is going to be fun, people. Okay, so the first... Hi, JL.
Hi, Mike. Good to be here.
Hey, I love doing these, man. You never know what you're going to talk about, and they're always fun. Okay, so we're going to start off with the aggravated assault deadly weapon charge. Now, this guy's struggling with teenagers across the street, for a while. And you know how aggravating these guys are when they're like involved with gangs or think they're involved with gangs. On their Facebook page, they're throwing up gang signs. So they very well could be, involved with gangs. But you know how boastful and intimidating and aggravating they are? So the guy goes outside with his long gun hanging across his chest in a down, safe hang position. So it's on a strap and it's just pointing at the ground. So he told them very loudly to turn their music down because it was blaring and it was irritating him. And the kid's mom called the cops. So let's find out what happens.
So in this case, this guy's never been in trouble before. He's a professional, married. He was going through a hard time emotionally. He had been drinking, but he was so irritated, and this was not the first time he had a run-in with these teenage kids. So he goes out there, and he tells them, turn that music down, And so they run in and tell the mom, this guy's got a gun. She comes out, says she peeks around the corner, sees the gun, says he pointed it at her, which did not happen, calls the police. The police come, and they arrested him for misdemeanor deadly conduct. But over the course of the time that he was waiting for his court date, the prosecutor decided to upgrade the charge to aggravated assault with a deadly weapon.
Oh, God.
Well, I knew because on the body cam, when the police were taking the report, the woman's husband was not satisfied with a misdemeanor. He wanted more. So the charge gets upgraded to aggravated assault with a deadly weapon. So it moves up to felony court where the judge puts an ankle monitor on him, which he had almost for a year. It rubbed blisters. It scarred his skin. It was a big brick. He had to hide it from his employer. But the first offer when I got on the case was like 7 years in prison.
Oh, my God. Well,
Yeah.
Wait a minute. Why did he have a gun strapped to? I mean, that's not a normal thing.
No, but he had been hunting. He was at home cleaning his guns. He had it strapped across him because, of course, he didn't know what he was going to walk into when he was hollering at these kids, knowing the history, and probably not the smartest move. But my first question, if I was going to pick a jury in this case, was, do you think it's illegal to stand on your driveway with a gun? He never left his driveway. That's his residence. He owns the gun legally. He didn't point it at anyone, but that was the allegation. So anyway, watching the body cam, I get to the portion where the kids didn't stay in that house, the friend. He was probably the most honest witness. And he said, yeah, he came out and told us to turn the music down. It was loud. And he said he didn't really ever point the gun. He just kind of lifted it, but didn't never directly point it. So the next offer was 10 years deferred on a felony, but had to keep the ankle monitor.
Oh, my God.
So we set it for trial, and on the eve of trial, they came down to the original misdemeanor deadly conduct, which they had originally filed against the guy, and 2 years deferred probation. If he successfully completes it, he can get this off his public record and put this whole thing behind him.
Man, that's just. I mean, it is kind of odd that he had the gun strapped across him, but if he never utilized it in a threatening manner, I mean, he could have been inside cleaning his gun, and he just got tired of the bang, bang, bang. You drive down, you can really kind of put yourself in his shoes because the music that these kids play, they put these speakers in that vibrate houses like volcanoes, right? And even driving down the road, it's just irritating to sit at a stoplight and listen.
Right. And like I said, it wasn't the first run in, but the police did make entry into his home because they were nice to, lock things up for him and everything. So his story about what he was doing was corroborated by the evidence.
Well, great representation gets him off to where he can put this thing behind him. He does have to go through the probation, but he shouldn't have had a gun strapped across his waist or across his body. So, all right. So let's move to the next story. Aggravated assault. Oh, no, I'm sorry. I'm looking at the wrong thing here.
Go up one to the domestic violence.
Domestic violence, right. Okay, I started off with the wrong one. Okay, felony assault domestic violence. Okay, so this is a married couple. They've been married for years, and they've been sober for years. So he relapses, gets intoxicated, came home. They got into a fight. The cops were called by the neighbor. It's always the neighbor calls the cops.
Right.
Right. So they must have been yelling and screaming and creating some commotion. So what's the story here?
Okay, so this couple's been married for a long time. They have kids together, and they don't have these types of problems whatsoever. But he comes home drunk, and she's like, "You're not coming in here like that." So she starts pushing him out the apartment door into like the common stairwell area. Mm-hmm. And that's where the neighbor sees the struggle, and so she calls 911. But it was kind of funny because before the neighbor calls 911, when he's being told he's going to get out of the house, he's drunk, he's not making the best decisions. And my favorite part about it is that he said, "Well, if I'm going, I'm taking my TV with me." So he goes back in and he pulls the TV, which was plugged in. He yanks the TV off of the countertop that it was on, and everything falls over, and the house looks like a wreck, like they've just really been going at it. But it was just because he wanted his TV to go with him. I don't know where he was going, but so anyway,
to the car.
Yeah. When the police get there, they decided to arrest him for basically it's a Class A assault, like a misdemeanor assault. But because he had a prior conviction many, many years ago, mm-hmm. then it's upgraded to a felony. Oh. Otherwise, this would have been a misdemeanor. And he did not have good representation back when he got the first conviction. So I talked to that victim from that case, and he should have never pled to that. But he did, and so now this was a felony. So the first offer was 5 years deferred probation. We turned it down. We asked for an informal pretrial intervention program because we showed all kinds of great things that he's been doing. We were turned down. I set it for trial, and on the Sunday night before our Monday trial setting, the prosecutor dismissed the case. And here's why. When you have a domestic violence case where the victim doesn't want to come forward or testify or have anything to do with the prosecution, as a prosecutor, you have to look at other ways you can prove the case, mm-hmm. whether it's a 911 or pictures or statements or ambulance or hospital records or, in this case, a neighbor. But the neighbor did not want to cooperate with the state, so they had no choice but to dismiss the case for insufficient evidence of guilt.
Bet that was a relief.
Oh, yeah.
But you know what's really interesting about this? You can't even get in a damn argument anymore without being charged with a felony.
It depends on the
circumstances.
circumstances.
Because there wasn't any physical abuse,
Well, and his wife's not a small lady, so... she can hold her own, but, and we were talking about this neighbor's calling. I was telling you that in another case, when the neighbor called, she gave a fake name because she didn't want to be involved. And the only reason I knew her real name was because I saw her ID on the officer's body cam.
Well, I got news for you. The way electronics works today, you can't do that unless you got a burner phone on hand.
Yeah. In that case, she didn't even see anything. She only heard things.
So that doesn't make for a good witness.
No, not at all.
Yeah. So I live in an apartment, and I hear all kinds of crazy things, but and definitely hear all kinds of pounding noises. So that's kind of like day in the life these days. All right, so now let's talk about the felony DWI. Now, this man has been on probation for a felony DWI in another county. Then he gets another DWI in a different county, but there's no alcohol involved. He's actually taking prescription medications, Xanax, and he's on the border of therapeutic range.
Correct.
So what in the heck is up with that? So you can get a DWI without actually drinking alcohol?
Yeah, so a lot of people don't know that. You can get a DWI for anything that intoxicates you. So if you put something in your body that makes you lose the quote unquote normal use of your mental and physical faculties and makes you intoxicated, that can be a DWI. It can be pot, it can be pills, it can be alcohol, anything that can intoxicate you. But in this case, the guy had been struggling for a while, and he was actually on doctor's prescription for Xanax, and they arrested him. They took his blood. It took us forever to get his blood back. But mainly, when you are on a felony probation and you pick up a new case, whether it's a misdemeanor or especially a felony, you're looking at going to the penitentiary. Like, that's game over. But when the blood came back, it showed that the Xanax that he was taking was within the therapeutic range, a little on the border of potentially intoxication. So the state didn't want to just give me a full dismissal. What they decided to do was reduce it to a misdemeanor DWI. And he had gone to treatment. He was inpatient. He did supportive. He had been on bond for a long time where he was testing constantly and giving clean urinalysis tests. So in the end, he did a little bit of time on the misdemeanor, and then they reinstated his probation in the other county so he can continue on, because he's also the sole provider for his family. So if he was in the penitentiary, it's not going to make their family life much easier.
Okay, so back up. How does the cop know, or what is the cop, what gives that cop the indication that he's in this state to where that cop can say, I'm going to put you in cuffs and take you down?
So this officer in particular has a lot of bad marks against him, but he pulled the client over on traffic, and he felt like the client was slurring, unsteady on his feet. It's the time of night. It was like in the early morning hours. I think it was like around 1:30 in the morning, something like that. So a time when you would normally see people coming home from bars.
Mm-hmm.
And so the officer only has to have the level of probable cause to make an arrest. And oftentimes when I'm doing a DWI trial to a jury, I'll tell the jurors, look, the officer did his part at that tiny level of probable cause by taking a potential dangerous person off the street. But the state didn't prove their case beyond a reasonable doubt, so it's time for you to do your job and find the client not guilty. And that's how the system works.
Okay, so it's really if that cop's perception is that you are not in control of your faculties, well, for whatever reason, right? Then they have the right to go ahead and put the cuffs on you and take you down.
Yeah, and in this case, even if he had done a breath test, you're not going to have any alcohol. So they
Right.
had to get a warrant to get blood.
Interesting stuff. So you got it reduced to a misdemeanor.
Correct.
Bottom line. And, it's, do you find, are there any shocking DWI cases that you represent that you're going, what the hell?
Like, as far as like them being super intoxicated?
Like with, police, like kind of overgoing. I mean, because everybody that goes to a bar is going to have one or two drinks, right?
Oh, yeah. Well, I think we talked about this one in the past where my little client who had never been in trouble before had a .07 breath test.
Mm-hmm.
And the only reason that they came in contact with her was because she had a small fender bender in a horribly marked construction zone. But when the police officer got to the scene, she was walking the curb like a balance beam. And she thought, I'll cooperate, I'll give a breath test, and I'll go home.
Mm-hmm.
And a lot of times when I'm picking juries in DWI cases, I'll ask the panel, how many of you think if you cooperate with law enforcement and you give a breath test and it comes back less than .08, you're going home? And a lot of them raise their hands. But they're not, because in that case, the officer in charge said, well, she might have been over at the time of driving and eliminated the alcohol to .07 by the time she gave the breath test. But that wasn't the case. And we could show that by her behavior on the video.
Okay, so going back, you're incarcerated and you have the opportunity to provide blood, should you?
I wouldn't make the state's evidence any easier for them. I
So
mean, it's not my
no,
job.
even if you blow and you're below the meter, right? Do you recommend blowing into that meter?
No, because you can't retest it, right?
Okay.
So once you give a breath sample in that machine and you get a readout, that's what they have etched in stone as their evidence. And there's no way for defense counsel to go back in and retest that breath sample. And so many things can interfere with a breath test machine. Even cell phones can interfere with a breath test machine. Diabetes can interfere,
Well,
you burp.
the important thing to understand is you're going to jail, period.
Right.
Okay. So you're not going to avoid going to jail by doing that test. You're just contributing to your prosecution.
Right, exactly. And I always say, be cooperative with law enforcement, but know your rights. You don't want to be ugly to an officer who's out there trying to protect us, right?
No, I don't disagree. I think you should be cooperative, but when people are drinking and they get pulled over, they're scared and they have a tendency to you assume you're going to jail,
right?
When you get pulled over. I mean, you just assume it.
Yeah, I mean, there have been cases where they've let someone go, but it's rare, and especially in these days of liability. So, just you don't have to contribute to the state's evidence, but you don't have to be ugly either. Just wait and hire a great lawyer and work it out in the courtroom.
Well, if you go to jail, call JL, because that is the solution. You can call her at 713-201-6767. It's JL Carpenter. You can find her online.
JLCarpenterlaw.com.
That's it. So hope you guys enjoyed the series. Hope you learned something. We'll have another one out for you soon.
I wanted to be a voice for those that may not necessarily have a voice of their own. I practice law because I care about helping people get out of situations. And it's rewarding to help bring the truth to light for folks who are wrongfully accused. Sometimes I'll say, I represent the misunderstood.